Virginia firearm owners. You must pay careful attention because what originated as flawed legislation has transformed into an absolute disaster. Senate Bill 749 was already problematic when first introduced as a restriction on modern sporting rifles and standard ammunition magazines. However, after undergoing review by the Senate Committee on Courts of Justice, it emerged completely rewritten, with modifications that could instantly criminalize millions of Virginia residents. We are examining a single-word alteration that shifts this proposal from grandfathering your existing magazines to making every standard capacity magazine you currently possess illegal contraband immediately. One word. That is the entire difference. So let us analyze exactly what Senate Bill 749 states, what was changed in committee, why this change matters so profoundly, and what constitutional protections this proposal will challenge if it reaches the governor's desk. Because, Virginia, you are now positioned at the epicenter of a major Second Amendment conflict. The legislative situation in Virginia. Before we examine Senate Bill 749 specifically, let me provide the broader picture of what is unfolding in Richmond right now. There is an absolute avalanche of gun control legislation moving through the Virginia General Assembly this session. We are not discussing one or two isolated bills. We are facing dozens of proposals aimed at restricting Second Amendment rights throughout the Commonwealth. Senate Bill 749 is merely one element of this larger assault on firearm ownership. But it is a particularly dangerous element because of how it evolved during the legislative process. And what makes this even more alarming is that this bill received bipartisan support in committee, which means it has a realistic chance of becoming law. Virginia has traditionally been viewed as a relatively gun-friendly state, especially compared to states like California, New York, or Maryland. But what we are witnessing now is an aggressive campaign to transform Virginia into another anti-gun jurisdiction. And if these bills pass, Virginia firearm owners will find themselves in the same position as owners in the most restrictive states in the nation. So let us discuss what Senate Bill 749 actually does and how it was altered. Understanding the terminology. Before we get into the specific details of the bill, I need to address some terminology because this is crucial for understanding the full scope of what we are dealing with. When I use the term assault weapon in this presentation, I am not endorsing that terminology. I am using it because that is the term used in the legislation itself, and I want to be very clear about something. This is not just about AR-15s or AK-47s. Senate Bill 749's assault weapon ban includes semi-automatic pistols and several categories of shotguns. This is a comprehensive ban on commonly owned firearms that millions of Americans use for self-defense, home defense, hunting, and competitive shooting. And when I discuss magazines, I am referring to what the bill calls large-capacity ammunition feeding devices. According to this legislation, the Constitution apparently protects magazines that hold 10 rounds or less. But once you reach that 11th round, suddenly, it is no longer protected. This is what I call the magic round theory. Somehow, the Founding Fathers who wrote the Second Amendment when citizens owned cannons and warships decided that 10 rounds was the constitutional limit. 11 rounds. That is where they drew the line. It is absurd on its face, but that is the framework we are working within in this legislation. So keep that in mind as we go through the details. The original version of Senate Bill 749. Senate Bill 749 was introduced on January 19, 2025. In its original form, the section dealing with magazines stated the following: any person who imports, sells, barters, or transfers a large-capacity ammunition feeding device is guilty of a Class 1 misdemeanor. Now notice what is missing from that list. Possession. The original version did not ban possession of magazines over 10 rounds. It only banned the commercial sale, import, barter, or transfer of new magazines going forward. This is similar to what Washington State did with their magazine ban. By not including possession in the prohibited conduct, you effectively grandfather in all existing magazines. If you already own standard capacity magazines, you get to keep them. You just cannot buy new ones or transfer the ones you have to someone else. It is still a bad law. It still violates the Second Amendment, but at least it does not retroactively criminalize millions of firearm owners for property they already legally own. That was the original version, and if that version had passed, Virginia firearm owners would have faced restrictions on future purchases, but their existing collections would have been protected. But that is not what happened. The committee rewrite, where one word changes everything. Senate Bill 749 went into the Senate Committee on Courts of Justice for review, and when it came out of that committee, it had been rewritten. The new version of the section dealing with magazines now reads, "Any person who imports, sells, barters, transfers, purchases, or possesses a large-capacity ammunition-feeding device is guilty of a Class 1 misdemeanor." Did you catch the change? Let me highlight it for you. The committee added 2 words: purchases and possesses. That addition of the word possesses fundamentally transforms this bill. It is no longer just a ban on future commercial sales. It is now a ban on possession of magazines you already own. Think about what that means. Practically every standard capacity magazine sitting in your safe right now, every magazine you bought legally last year, 5 years ago, 10 years ago, would instantly become illegal contraband. The moment this bill is signed into law, you would not be grandfathered in. You would not get to keep what you already own. Everything you have that holds more than 10 rounds would have to be destroyed, rendered permanently inoperable, or surrendered to law enforcement. This is exactly the situation that California firearm owners are facing in Duncan v. Bonta, the case currently pending before the Supreme Court. And if I were a Virginia firearm owner, I would be watching that case very carefully, because the outcome of Duncan could directly impact how Virginia's law is challenged. The practical impact on Virginia firearm owners. Let me put this in personal terms so you understand the real-world impact of this law. Think about your own firearm collection right now. How many magazines do you own that hold more than 10 rounds? If you own a Glock 17, the standard magazine holds 17 rounds. If you own an AR-15, standard magazines hold 30 rounds. If you own any modern semi-automatic pistol or rifle, chances are the magazines that came with exceed this arbitrary 10-round limit. Now, multiply that by the number of guns you own. Most responsible firearm owners do not just have one magazine per firearm. You probably have multiple magazines for each gun. Maybe you have 3 or 4 magazines for your carry pistol. Maybe you have a dozen magazines for your AR-15. If you are like most firearm owners, you probably have dozens of magazines in your collection. That would be criminalized under this law. Some of you might have hundreds. And here is the critical part. Each magazine would be a separate criminal offense. This is not one charge for violating the law. It is one Class 1 misdemeanor charge for every single magazine you possess. A Class 1 misdemeanor in Virginia carries a maximum penalty of 12 months in jail and a fine of up to $2,500. Now, would they actually prosecute every magazine as a separate charge? Maybe, maybe not. But the law, as written, allows for it. So if you have 20 magazines that violate this law, that is 20 separate criminal charges you could potentially face. The financial penalties alone could be devastating, not to mention the possibility of jail time and a criminal record that could affect your ability to own firearms in the future. The Fifth Amendment takings issue. Now, beyond the Second Amendment issues, which are obvious and significant, Senate Bill 749, in its current form, raises a separate constitutional problem: the Fifth Amendment's prohibition on takings without just compensation. Let me read to you the relevant portion of the Fifth Amendment. "Nor shall private property be taken for public use without just compensation." This is called the Takings Clause, and it is designed to prevent the government from confiscating private property without paying fair market value for it. Now, think about what Senate Bill 749 does with the stroke of a pen. The governor would render your magazine collection completely worthless. You could not sell them because that would be illegal. You could not transfer them because that would be illegal. You could not even possess them because that would be illegal. Your only legal options would be to destroy them, render them permanently inoperable, or surrender them to law enforcement. In any of those scenarios, you receive nothing in return. The government has effectively taken your property without compensation. Is that constitutional? That is a question courts would have to decide. But there is a strong argument that forcing firearm owners to destroy or surrender property that was legally acquired without providing any compensation violates the Fifth Amendment's Takings Clause. This creates an additional avenue for challenging this law beyond the Second Amendment arguments, and depending on how courts interpret the Fifth Amendment in this context, it could provide another path to striking down this legislation. The Supreme Court has generally held that regulatory takings, where the government does not physically seize property but makes it worthless through regulation, can violate the Takings Clause. The question is whether courts would apply that principle to firearms and magazines. Second Amendment challenges. Of course, the primary constitutional challenge to Senate Bill 749 would be based on the Second Amendment, and there are several strong arguments against this law under current Second Amendment doctrine. First, there is the common use doctrine established in District of Columbia versus Heller. The Supreme Court held that the Second Amendment protects arms that are in common use for lawful purposes. Standard capacity magazines are unquestionably in common use. There are hundreds of millions of them in circulation across the United States. They are the default magazines that come with the vast majority of modern semi-automatic firearms. Second, under the Bruin standard established in New York State Rifle and Pistol Association versus Bruin, the government has to demonstrate that magazine restrictions are consistent with the nation's historical tradition of firearm regulation, and there is no historical tradition of limiting magazine capacity. Magazines did not even exist during the founding era, and when they were developed, there were no capacity restrictions. Third, the dangerous and unusual test from Heller. The court said the Second Amendment does not protect dangerous and unusual weapons, but standard capacity magazines are neither dangerous nor unusual. They are standard equipment. They are ordinary. They are common. All of these doctrines support the argument that Senate Bill 749 violates the Second Amendment, and if this law passes, you can expect immediate legal challenges based on these principles. The problem is that litigation takes time. It could be years before these cases are fully resolved, and in the meantime, Virginia firearm owners would be living under an unconstitutional law, unable to possess property they legally acquired the compliance problem. Now, I know some of you are sitting there thinking, I am just not going to comply. I am going to keep my magazines regardless of what the law says. I understand that sentiment. I really do. Civil disobedience has a long and important history in America, but I want you to understand the risks you would be taking. If you choose not to comply with this law, you are committing a crime. Multiple crimes. Actually one for each magazine you possess. And while you might think law enforcement will not bother enforcing this, you cannot count on that. All it takes is one traffic stop where the officer sees a magazine in your vehicle. All it takes is one home incident where police respond and see magazines in your house. All it takes is one disgruntled neighbor or ex-spouse reporting you to authorities. And if you are charged and convicted, you are facing potential jail time, significant fines, and a criminal record. That criminal record could impact your ability to own firearms in the future, your employment opportunities, your professional licenses, and various other aspects of your life. I am not telling you what to do. That is a decision every individual has to make for themselves based on their own conscience and their own risk tolerance. But I am telling you to make that decision with full knowledge of the potential consequences. The better approach is to fight this law before it passes. Contact your state legislators, show up at committee hearings, make your voice heard, and if it does pass, support the legal challenges that will inevitably be filed. What you need to do right now. So, what should Virginia firearm owners be doing right now? While this bill is still moving through the legislature, first contact your state senator and delegate immediately. Tell them you oppose Senate Bill 749 and any other gun control measures being considered. Be polite, but firm. Let them know this is a voting issue for you. Second, stay informed about the legislative process. Know when committee hearings are scheduled. Know when floor votes are happening. The more informed you are, the more effectively you can advocate. Third, show up if you can attend committee hearings or rallies. Do it. Legislators need to see that their constituents care about these issues. Empty hearing rooms send the message that nobody cares. Fourth, support Second Amendment organizations that are fighting these laws, whether it is the Virginia Citizens Defense League, Gun Owners of America, the Second Amendment Foundation, or other groups. They need resources to fight these battles. Fifth, spread the word. Make sure other firearm owners in Virginia know what is happening. A lot of people are not paying attention to the legislature. They need to know what is at stake, the broader implications. Finally, I want to zoom out and talk about what this means beyond just Virginia. If Senate Bill 749 passes in its current form, it will embolden anti-gun legislators in other states to pursue similar laws. They will look at Virginia and say, if we can do it there, we can do it anywhere. And if Virginia, a state with a strong gun culture and a history of respecting Second Amendment rights, can pass a comprehensive magazine and assault weapon ban with possession penalties, what does that say about the future of gun rights in America? This is bigger than just Virginia. This is about whether we are going to allow the incremental erosion of constitutional rights to continue unchecked. It is about whether we are going to stand up and fight for our rights or sit back and watch them disappear. Virginia firearm owners, you are on the front lines of this battle right now. What happens in your state legislature over the next few weeks will have implications far beyond your borders. Senate Bill 749 went from bad to worse with a simple committee rewrite. What started as a future sales ban became a retroactive possession ban that would criminalize millions of law-abiding Virginians overnight. This is exactly the kind of constitutional overreach that the Second Amendment was designed to prevent, and it is exactly the kind of law that needs to be challenged and defeated. If you are in Virginia, now is the time to act. Contact your legislators, show up to hearings, and make your voice heard. Your rights are on the line. I will be tracking this bill and others as they move through the Virginia legislature. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.